Supranational law, the big picture. When we think about criminal law, most of us imagine national law, laws made by your country's parliament. But surprise, surprise, national law isn't living in a bubble anymore. The world's gone global, baby, and supranational law is flexing its muscles. Now, can supranational bodies directly create crimes or hand out punishments in your country? Nope. That's because only representative bodies like parliaments can make criminal laws. Supranational bodies aren't directly elected by your peeps. But don't let that fool you. Supranational law still packs a punch through its indirect effects. Two big players in Europe. European Convention on Human Rights, ECHR. Linked to the Council of Europe, not the EU. Folks, don't mix them up. This bad boy sets criminal law safeguards, e.g. Article 7. No punishment without law. Article 2. Right to life. National parliaments can't make laws that clash with the ECHR. Why? Because international law, domestic law in the hierarchy of norm. European Union, EU. The EU has a double-decker law system. Primary law treaties, like the Lisbon Treaty of 2009. Secondary law, regulations and directives. EU law, regulations versus directives. Regulations. These are the big dogs. They've got direct effect. They apply in every member state like local law. Judges love them. If a domestic law clashes with an EU regulation, the EU law wins. The national law? Poof, disapplied. Directives. More subtle directives don't kick down the door. They set goals for member states to achieve through their own laws. Member states have to create domestic laws that align with the directive's goals. If they mess up or drag their feet, judges can't directly apply the directive, but they can flag the domestic law as unconstitutional. Italy's take, Article 117. Italy has a clever trick up its sleeve, Article 117 of its constitution. It says Italian laws must play nice with international and EU laws. If a domestic law clashes with a directive, the judge can call it out as unconstitutional. The bottom line, supranational law doesn't directly hand out punishments or define crimes, but it's like that quiet kid in class who gets straight A's. It influences everything. National laws can't afford to ignore it, and judges? They're always keeping one eye on the EU and ECHR rulebooks. When supranational laws knock, national laws better listen because the international wave is unstoppable. No direct competence, no problem. The EU does not have direct competence in criminal matters. Here's why. No treaty provisions. The European treaties simply don't give the EU the power to create or enforce criminal laws. Principle of legality. Criminal law must be rooted in legitimacy and democratic representation. EU organs like the Commission with both executive and legislative power aren't directly elected. If they could introduce criminal laws, it would shake the very foundation of legality. Bottom line, the EU can slap administrative sanctions, but criminal offenses? That's off limits. Then why talk about European criminal law? Great question. While the EU can't directly legislate criminal matters, its influence over criminal law has grown significantly. Let's unpack the evolution. Key drivers behind the EU's criminal law expansion. Transnational crimes. Certain crimes like drug trafficking, terrorism, and organized crime aren't contained by borders. These bad actors operate across countries, so national governments need to cooperate to fight them effectively. The Common Market Internal Market Law. With the abolition of borders and free movement of goods, people, and capital, the Schengen area created opportunities not only for trade, but also for cross-border crime. Protecting the financial interests of this internal market? Sometimes that requires criminal law. Post-Cold War political shifts. The fall of the Berlin Wall and the collapse of the Soviet bloc in the late 80s brought political instability and fears of increased crime spilling from east to west. The securitization of crime. In an age of terrorism and rising security concerns, criminal law became a frontline defense. Threats that once seemed isolated are now global, demanding harmonized responses from member states. What can the EU do? While the EU can't directly create criminal laws, it has found ways to influence member states. Directives. These require states to harmonize their laws to achieve certain goals, often including criminal penalties for serious issues like money laundering or human trafficking. Judicial cooperation. Through initiatives like the European Arrest Warrant, the EU fosters cross-border legal cooperation. Framework decisions pre-Lisbon. Before the Lisbon Treaty 2009, framework decisions were tools for standardizing criminal law among member states. The takeaway. European criminal law exists not because the EU writes the criminal codes, but because it pushes states to coordinate and align their laws to tackle shared challenges. It's a balancing act. National sovereignty meets supranational cooperation. When it comes to crime, the EU says, if we can't legislate, we'll collaborate. From Maastricht to Lisbon, a criminal law evolution. 1. The Maastricht Treaty 1993. The three-pillar structure? The EU first dipped its toes into criminal law with the Maastricht Treaty. Think of it as a European experiment with shared authority. Pillar 1. Supranational matters like trade, the big stuff. Pillars 2, 3. Intergovernmental, purely about cooperation, no power to legislate directly. Criminal competence was introduced under Pillar 3, but it wasn't about making laws. It was about governments holding hands and singing the cooperation anthem. 2. The Amsterdam Treaty 1997. Framework decisions arrive. By 1997, the EU realized it needed more than just kumbaya moments. Enter the framework decisions. Legally binding instruments that let the EU impose obligations on member states. Domestic courts now had to interpret national laws in line with EU directives under the principle of conforming interpretation. But hold your objections, there's a critical limit here. Counter limits principle. No interpretation can violate the principles of legality and non-retroactivity in criminal law. 3. The Lisbon Treaty 2009, a criminal law revolution. This treaty took a wrecking ball to the old structure, abolishing the three pillars and granting the EU general competence in criminal law. But hold up, don't panic about EU overreach. Here's the fine print. Article 83(1). The EU can adopt directives to establish minimum rules for crimes with a serious cross-border dimension. Think of the usual suspects: terrorism, human trafficking, money laundering, cybercrime, organized crime, and more. The list can expand, but only by unanimous consent of the Council and with the European Parliament's nod. Article 83(2). If criminal law harmonization is essential for effective EU policy, directives can set minimum rules for offenses and sanctions. Important catch. The EU can't use regulations which have direct application to create crimes or penalties. Instead, it uses directives, which require member states to implement the rules domestically. What's the impact? Directives have become the EU's tool of choice to harmonize laws across member states. Here's how they hit. They are binding and often specific, leaving little room for states to make their own decisions. This has sparked controversy as states effectively relinquish their legislative discretion in criminal matters. For example, when the EU says, "You will criminalize cyber fraud," states are left with no choice but to comply, raising questions about democratic principles. The big picture. The EU's role in criminal law has grown from a quiet whisper in Maastricht to a commanding presence in Lisbon. While it still respects national sovereignty, its ability to harmonize laws and enforce cooperation shows that even in criminal matters, Europe has learned how to play the long game. So, whether you're a state hesitating to give up legislative power or a skeptic wondering how the EU handles crime, one thing's for sure: the EU knows how to make its influence felt. Let's talk about what happens when EU law and national criminal law throw down in the legal ring. Two kinds of showdowns. 1. National law versus EU treaties or regulations, big guns. If your country's law steps on the toes of an EU treaty or regulation, guess what? The judge can toss it out like yesterday's bad evidence. Example: Italy had a law making it a crime for expelled foreigners to come back, but EU rules said, not so fast, Italy. Judges started ignoring that law because the EU rule wins. 2. National law versus EU directives, not so direct. Directives don't pack the same punch. Judges can't just ignore your national law. Instead, they have to bend and twist the rules to make them fit the EU directive. If it's impossible, call the Constitutional Court to sort it out. Think of it like a legal emergency hotline. Help! My national law isn't playing nice with the EU. What happens when national law seems better for the defendant? Here's where we get to the good stuff, the Taricco case. What's the deal? Italy had a rule. If you don't prosecute someone within a certain time statute of limitations, they're off the hook. The EU wanted Italy to ditch that rule for fraud cases affecting EU money. But Italy wasn't so sure. The Taricco roller coaster. First round, 2014. Italian judges go, "Hey EU court, what do we do here?" EU court, 2015. Easy. Ignore your statute of limitations. Protect the EU's cash. Italy, 2017. Hold on, cowboy. You're messing with our core rules. We don't do retroactive punishments here. It's unconstitutional. EU backpedals, 2017. All right. Don't break your own constitution. We'll chill. Final decision, 2018. Italy rules. Non-retroactivity wins. No punishment for Taricco. What's the moral of the story? EU law isn't all-powerful. Sure, EU law usually wins, but it can't steamroll over a country's most sacred principles, like not punishing people retroactively. Judges gotta hustle. Judges work hard to balance EU rules and national laws. They're like legal acrobats trying to make it all fit. Constitution trumps all. At the end of the day, your country's constitution is the big boss. Even the EU knows when to back off. So, next time someone asks about EU and national law conflicts, you can tell them, it's all about the balance, baby. EU law sets the stage, but national constitutions call the shots when it really counts. International Criminal Law, ICL. The basics? Picture this, a courtroom where it's not just about one country's rules, but the world's rules. That's what international criminal law is all about. It's like the Avengers of law different countries coming together to handle the big bad guys no single nation can tackle alone. What's the deal with ICL? It's not your average national law. Normal criminal law is a country's business. Italy handles its own crimes. Germany handles theirs. ICL is a separate system. It's not just national law with a sprinkle of international influence. It's its own thing. A young field. It's a baby in the legal world, born after World War II to deal with the worst crimes: genocide, war crimes, crimes against humanity. ICL, the hybrid law. Why hybrid? It's a mix of public international law, deals with how countries interact, like treaties and conventions. Criminal law focuses on punishing individuals, not countries, for breaking big universal rules. Who's on the hook? Not countries. ICL goes after individuals, leaders, generals, warlords who commit international crimes. How does ICL work? International law as the blueprint. ICL gets its rules from international sources. Treaties, agreements between countries. General principles of law, the stuff every nation agrees is wrong, like murder or torture. Who applies ICL? International courts, tribunals, big names like the International Criminal Court, ICC, in The Hague. Tribunals set up for specific events like the Rwandan genocide. National courts. If a country adopts ICL rules into its own laws, their courts can use them too. This is the principle of complementarity. National courts get the first crack. But international courts step in if they fail. Why does ICL matter? Accountability for the worst crimes. Genocide, war crimes, crimes against humanity, these aren't just bad in one country. They're crimes against the world. No hiding behind borders. Leaders can't escape justice just because they're in power or in another country. ICL makes sure the world is watching. In short, ICL is like an international referee, stepping in when crimes are too big or messy for one country to handle. It's about punishing individuals, not nations, and making sure even the worst criminals face justice. The takeaway: international criminal law eagers justice for the world's most serious crimes, served up with teamwork and a lot of treaties. What crimes does ICL cover? ICL focuses on a limited set of crimes, specifically war crimes. These are crimes committed during armed conflicts. Think of actions like targeting civilians, using banned weapons, or mistreating prisoners of war. Crimes against humanity. These involve widespread or systematic attacks on civilians. Examples: mass killings, enslavement, torture, or forced disappearances. Crimes of aggression. This is about starting illegal wars or acts of aggression against other states. It used to be called crimes against peace. Genocide. The big one. Genocide is an autonomous crime and is the most serious of all. It's the systematic destruction of a particular group, ethnic, racial, religious, or national. Why do these crimes fall under ICL? These aren't your everyday crimes. They're so serious that they are considered mala and say evil in themselves. Everyone agrees they're crimes. No debate. Impact universal values. They threaten the peace and security of the entire world. Example: genocide isn't just a crime against one country. It's a crime against humanity as a whole. What's unique about these crimes? Context is key. These crimes don't stand alone. They happen in specific contexts. Crimes against humanity, part of a systematic or widespread attack on civilians. War crimes must happen during a war or armed conflict. Genocide requires intent to destroy a specific group. Context helps distinguish them from regular crimes. Example: murder in peacetime is a national crime, but the same act during a mass attack on civilians, that's ICL territory. Teamwork crimes. These crimes are often multi-subjective, meaning they involve coordination between multiple people. Leaders, not just foot soldiers, are held responsible. No get-out-of-jail-free cards. No immunities. Heads of state, government officials, or parliament members, they don't get a pass. No statute of limitations. You can't escape prosecution just because time has passed. Principle of legality applies. You can only be punished if the act was criminal under international law at the time. No surprise. Laws to retroactively convict someone. In a nutshell, ICL tackles the biggest crimes with global implications: war crimes, genocide, crimes against humanity, and aggression. It's about holding individuals accountable for acts that shock the conscience of the world, no matter their rank or position. Sources of international criminal law: ICL. ICL, being a specialized branch of law, draws on a variety of sources to define its rules and apply them in practice. Let's break it down simply. Key sources of ICL. International treaties and conventions. These are the backbone of ICL, providing written and agreed upon rules. Example: Rome Statute of the International Criminal Court (ICC), which establishes the court's jurisdiction and outlines crimes like genocide, war crimes, and crimes against humanity. Treaties like the Geneva Conventions also form part of ICL. Customary international law. Unwritten rules developed over time through consistent state practice and legal obligations. Example: the prohibition of genocide and war crimes is recognized as customary international law. Challenge: not being written can lead to vagueness, raising concerns about the principle of legality. General principles of law. These are principles recognized by civilized nations and are often drawn from national legal systems. Example, principles like no punishment without law or the right to a fair trial, found in Article 38 of the ICJ statute. National and international judicial decisions. Past rulings from courts, both national and international, help interpret and apply ICL. For example, decisions by the ICC, ICTY International Criminal Tribunal for the former Yugoslavia, or ICTR Rwanda Tribunal. Precedents play a significant role, as previous judgments are often binding or persuasive. Provisions in the Rome Statute Article 21. The ICC uses A. Its own statute, elements of crimes, and rules of procedure. B. Applicable treaties and principles of international law. C. General principles of law from national systems ensuring consistency with international norms. Challenges with customary law and general principles. Vagueness. These are unwritten or abstract, which can clash with the principle of legality that laws must be clear and specific. Interpretation issues. Customary practices vary, making universal agreement tricky. Historic evolution of ICL. Post-WW1 first attempt. The Treaty of Versailles 1919 tried to hold Kaiser Wilhelm II accountable for supreme offenses against international morality. Result: limited success. Kaiser fled to the Netherlands, and only 12 out of 800 accused were convicted during the Leipzig trials 1921. Post-WW2 major development. After Nazi Germany's defeat, the Allies chose to prosecute war criminals rather than grant impunity or punish without trial. International Military Tribunal at Nuremberg 1945. Based on the London Charter, signed on August 8, 1945. Tried Nazi leaders for war crimes, crimes against humanity, and crimes of aggression. In summary, the sources of ICL reflect its hybrid nature, combining elements from international law and criminal law. Treaties, customary practices, general principles, and court decisions form its foundation. While its historic evolution from WW1 to WW2 and beyond highlights its mission to ensure accountability for the gravest crimes. Who was in charge at Nuremberg? The IMT, International Military Tribunal, this big fancy court, was put together after WW2 to take down the Nazi big shots who did some seriously messed up stuff. Here's how it worked. Judges. The USA, UK, USSR, Russia, and France each picked a judge. They also had an alternate judge in case someone was busy doing something else. Prosecutors. The same 4 countries sent their prosecutors. They were the ones making the case to show the Nazis were guilty of some major crimes. Defendants. The big names were on trial, guys who ran the Nazi regime, planned wars, and orchestrated horrific stuff. They had rights, couldn't just throw them in jail without a lawyer. They got a chance to defend themselves. What crimes were we talking about? Here's where it gets heavy. These weren't your usual petty crimes. We're talking about the big 3. Crimes against peace. Basically, the Nazis started a whole world war, a big no-no. War crimes. This one's for all the illegal acts during war torture, killing civilians, that kind of thing. Crimes against humanity. Yeah, we're talking about the Holocaust here, genocide, torture, and all kinds of brutality. Note, at the time, genocide wasn't even a thing in the law yet, but Nuremberg set the stage for that. How did it all go down? So, what happened in the end? They started with 24 people on trial. Here's the breakdown. 3 acquitted, yeah, they walked free. 12 got the death penalty. 3 got life sentences. 4 got prison time, 10 to 20 years. And this all happened pretty quickly, 1945 to 1946. Controversial stuff. The trial wasn't perfect, far from it. There were a few big issues. Non-retroactivity. The Nazis said, hey, you can't punish us for stuff that wasn't even considered a crime when we did it. But the court said, sorry, buddy. Customary international law, everybody, knew killing millions of people was wrong. So, no sympathy there. Obeying orders. Another defense. We were just following orders. The court wasn't buying it. They said, if you're told to do something that goes against all human decency, you have to say no. You're still responsible for your actions. Justice of the victors. Critics said, this is just revenge by the winners. Only the Nazis were on trial, while the Allies didn't have to answer for their actions. But the court was like, tough luck. We have to make an example out of these guys to make sure this never happens again. The big takeaway. Despite all the drama and criticism, Nuremberg was a game changer. It made clear that leaders can be held accountable for horrible acts, no matter how high up they are. It was a huge step in international law. And even though people criticized the process, it set the stage for today's modern system of international justice. And that, my friend, is how Nuremberg went down making history and changing how the world handles crimes that affect us all. The big impact of Nuremberg trials. The Nuremberg trials didn't just throw some bad guys in prison, they laid down some serious rules that are still around today in International Criminal Law, ICL. Individual responsibility. This was huge. Before Nuremberg, people thought nations could just avoid accountability, but Nuremberg made it clear. Individuals can be held responsible for crimes even if what they did wasn't technically illegal in their own country. If you're part of a global crime, you're going down. No immunity for leaders. Doesn't matter if you're the president or the king of the world. If you commit an international crime, you can't hide behind your title. No immunity. Following orders doesn't let you off. A lot of the Nazi defendants said, I was just following orders. Well, the court said, tough luck, pal. That doesn't get you off the hook. You can be punished, but following orders might make your sentence a little lighter. Fair trial rights. Every defendant, even if they're a Nazi war criminal, gets the right to a fair trial. No. Summary justice, here everybody gets a day in court. More tribunals and trials? But hold up, Nuremberg wasn't the only show in town. After WWII, there were other tribunals big, global justice happening. Here's some of the key ones. International Military Tribunal for the Far East Tokyo Tribunal. This one's like the Nuremberg trials, but it focused on Japan. It started in 1946 and ran until 1948 with a similar setup to Nuremberg. 28 defendants all found guilty. 7 got the death penalty. The tribunal was set up by General Douglas MacArthur and followed the Nuremberg model pretty closely. But these trials focused more on the Japanese war criminals responsible for the atrocities in Asia, like the Nanking Massacre. Collateral Nuremberg trials, the secondary trials. These weren't the main Nuremberg trials, but were still important. They took place between 1949, and were handled by the American military tribunals. There were 177 defendants. 142 were convicted. 26 got the death penalty. More than 90 were sent to prison. These were really important because they went after lower-level Nazis who didn't make it into the main Nuremberg trials. The evolution of international criminal law. After all these trials, ICL kept growing. It wasn't just about WWII anymore. There were 2 big ages of development for ICL. 1. Age of codification, late 20th century. The world realized that the laws had to be clearer and better defined, so they started codifying them. Some major conventions were passed, and here's what you need to know. Geneva Conventions 1949. These were game changers because they set out the rules for how to treat people during war, especially civilians. The rules are about humanitarian treatment, things like no torture, no attacking civilians, and more. These rules became the baseline for international criminal law. And if states break them, they have to punish the perpetrators. Genocide Convention 1948. This one's huge. It defined genocide as a crime and made it clear that killing entire groups of people like the Holocaust is punishable under international law. Other conventions included laws against apartheid, torture, and racial discrimination, making the international community hold states accountable for certain human rights violations. What's the bottom line? The bottom line is that these laws set the stage for the world to hold individuals responsible for serious crimes no matter where they're from or how powerful they are. And that's why Nuremberg and the other tribunals were so important. They didn't just punish bad actors. They established the rules we still follow in ICL today. So, anyone who thinks they can get away with war crimes, genocide, or crimes against humanity because they're a big shot better think again. Ad hoc tribunals. A little history. In the early 90s, two massive conflicts rocked the globe and shook public opinion. The Yugoslavian War and the Rwandan genocide. These were not your regular conflicts. They hit hard because of their scale and brutality. Yugoslavia, this conflict was right in Europe's backyard. Big deal for the European continent. Rwanda, this one was shocking because of the sheer scale of the genocide. We're talking about mass murder on an unimaginable level. After these horrors, the UN Security Council, UNSC, stepped in, creating two ad hoc tribunals to hold people accountable for these crimes. One, ICTY, International Criminal Tribunal for the former Yugoslavia, 1993. Why it was created: to prosecute war criminals responsible for violations of international humanitarian law in Yugoslavia after 1991. Where it was based: The Hague, Netherlands. When it operated: 1993-2017. Convictions: 90 people were convicted. No death penalty, since it was abolished by then. 2. ICTR, International Criminal Tribunal for Rwanda, 1994. Why it was created: to prosecute those responsible for the Rwandan genocide and other serious violations of international law. Where it was based: Arusha, Tanzania. When it operated: 1995-2015. Convictions: 62 people were convicted, including the head of government. What makes these tribunals similar and different to Nuremberg, Tokyo? Like the Nuremberg and Tokyo tribunals, these were ad hoc, meaning they were set up after the fact to deal with specific crimes tied to specific. They didn't create new laws, they were enforcing existing international humanitarian law. But there were some key differences. No retroactivity issue. These tribunals didn't deal with new crimes they were prosecuting, crimes that were already defined under international law. UN-led. Unlike Nuremberg and Tokyo, which were created by the victorious powers, the UN was behind these tribunals, making them more legitimate and less about revenge. Genocide focus. These tribunals were huge for defining genocide, especially in Rwanda, where it was the first time genocide was convicted. Mixed or internationalized domestic tribunals. Late 90s, as the 90s wore on, more ad hoc tribunals popped up, such as the Special Court for Sierra Leone. These tribunals were a little different. Mixed composition. They included both international and local judges and experts. The idea was to get some local involvement while still having international oversight. Based on domestic law, they were set up under domestic law with UN agreements. This helped make them feel more connected to the local communities. Local, global balance. The goal was to blend international standards with respect for local cultures and sovereignty. But here's the flip side: trying to keep things fair in places where influential local figures might still be involved or calling the shots. The big deal: the ICC, International Criminal Court. Now here's the real game changer. The ICC is like the superpower of international criminal law. It was created by a multilateral agreement, not by a single country or group of victorious nations. Established July 17, 1998, at the Rome Conference. When it started. The ICC became active in 2002, after 60 countries ratified the Rome Statute. To date, 123 countries have signed up, though some big names like the US and Russia haven't. What makes the ICC special? Permanent. Unlike the ad hoc tribunals, the ICC is here to stay. It's permanent, meaning it's always available to prosecute international crimes. Jurisdiction. The ICC can prosecute crimes that happen in any country that's signed up to the Rome Statute. It doesn't have universal jurisdiction, but its goal is to have a universal system of international law. Criminal law codification. The Rome Statute is like the rule book of the ICC, clearly outlining the crimes it can judge and the procedures it follows. Complementarity. The ICC doesn't step in unless national courts are unable or unwilling to prosecute crimes themselves. The bottom line? The ICC is the world's permanent solution for international crimes, like war crimes, genocide, and crimes against humanity. It's built on international cooperation and aims to keep criminals from escaping justice, no matter where they're from or how powerful they are. So, while past tribunals focused on specific conflicts, the ICC is a global system that works to keep humanity's worst crimes in check. It's a big step towards a world where nobody, no matter their power, gets away with atrocities. Lebanese Tribunal. A special case. This one's a bit of a curveball compared to other international tribunals because it mixes national law with international involvement. Here's the rundown. Name: Special Tribunal for Lebanon STL. Location: based in The Hague, Netherlands, but focused on Lebanese law. Established 2006 through an agreement between Lebanon and the UN Security Council. How did it come about? Here's where it gets interesting. Ratification drama. While Lebanon agreed to the tribunal, the Lebanese parliament never actually ratified the agreement. The UNSC step in. The UN Security Council invoked Chapter 7th of the UN Charter, which allows them to take action to maintain peace and security, even without Lebanon's full legislative approval. In other words, the UN bypassed Lebanon's parliament to set up this tribunal. They argued it was necessary to pursue justice, especially for the assassination of the Lebanese prime minister. Jurisdiction: a mixed bag. Now, here's another twist. International in nature. Even though it's an international tribunal located in The Hague, the law applied is national, based on Lebanese criminal law. Focus. The tribunal's focus was on crimes like terrorism, particularly around the assassination of Prime Minister Rafik Hariri in 2005. The perpetrators were accused of crimes that were also violations of international law, but the actual charges fell under Lebanon's criminal law system. Key peculiarity: the STL is a hybrid. It's an international tribunal, but it applies national criminal law. It shows the flexibility of international justice systems, using national legal principles to handle some very serious crimes while still bringing in international oversight. So, while it's international in setup, its focus on national law makes it a unique hybrid model in international criminal law. Cool, right? Transitional justice. The path from conflict to healing. Transitional justice isn't just about holding people accountable. It's about healing the past and moving forward after a conflict. Here's a simple breakdown. Purpose. It's a way for societies to come to terms with their past, particularly after periods of conflict or regime change. The goal is to rebuild trust and establish justice both for victims and for society as a whole. ICL's role. International Criminal Law ICL is part of transitional justice. It focuses on punitive measures like trials for war crimes or human rights violations like Nuremberg, Rwanda, or Yugoslavia. It's retributive. You commit serious crimes, you face punishment. But it's not the only way to address the past. Broader scope of transitional justice. Transitional justice extends beyond punishment. It's more than just court trials. It involves several other mechanisms, such as truth commissions, groups that investigate and uncover the truth behind atrocities, helping people understand what happened. Reparations, recognizing the suffering of victims and providing compensation or support. Public apologies, acknowledging past wrongs at the state level. Memorialization, creating memorial sites and days to remember victims and honor those lost. The focus isn't just on punishing perpetrators, but also on reconciliation, bringing society back together after deep divisions. Restorative justice, rebuilding relationships. Unlike the retributive nature of ICL, restorative justice focuses on healing and reconciliation. The goal is to rebuild relationships between victims and perpetrators. It's about restoring peace and ensuring that the atrocities are acknowledged. Examples. Think of South Africa's Truth and Reconciliation Commission. They gave amnesty to perpetrators of apartheid in exchange for full truth-telling. The idea was to rebuild society without creating further divisions. International Criminal Court, ICC, a permanent court for global justice. The ICC is a permanent institution that deals with the most serious crimes like genocide, war crimes, and crimes against humanity. Let's break it down. Established in 2002 with the Rome Statutea Multilateral Treaty. Location: based in The Hague, Netherlands. Jurisdiction: it covers crimes that happen in countries that are part of the system or crimes committed by nationals of those countries. 123 states have signed up to this, but some major powers, like the USA, China, Russia, and India, haven't. This has led to criticism about selective justice and accusations of colonialism. Challenges, criticisms of the ICC. While the ICC has achieved significant milestones, there are some critiques. Colonialism and hypocrisy. Some argue the ICC targets weaker or less powerful states, while powerful countries like the USA or Russia are often exempt from scrutiny. Disillusionment. Support for the ICC has waned somewhat due to the rise of populism and liberal democracy crises, but still, it remains critical in tackling human rights violations. Bottom line, the ICC's impact. Even with its flaws, the ICC is one of the few institutions that can enforce international justice. It remains a vital tool for accountability in a world where serious human rights violations still occur. The challenges in ensuring fairness and addressing the concerns of those who feel the court may not always be impartial. So, while it's not perfect, the ICC is an important player in the global fight for justice, helping to shape a future where war crimes and crimes against humanity are met with consequences. Who runs the ICC? The ICC International Criminal Court is made up of 18 judges. These judges are picked for a 9-year term. But here's the kicker. These judges can't all come from the same country. They gotta be from countries that signed the Rome Statute, basically. Countries that agreed to play by these international rules. What's the deal with the judges? They've gotta have good moral character, no shady business, and be top-notch lawyers in their home countries. Plus, they need to speak one of the court's languages, which is either English, French, or another official language. So, no slackers allowed. What crimes does the ICC handle? The ICC isn't about every little crime, just the big ones. We're talking about crimes like genocide, killing, or harming a group of people based on their race, religion, etc. War crimes, stuff like killing civilians during war or attacking hospitals. Crimes against humanity, things like slavery or torture. Crime of aggression, unprovoked attacks on country. It only deals with big-time crimes that affect everyone worldwide. Where and when does the ICC have power? The ICC has some rules about when and where it can get involved. Where the ICC can take cases if the crime happened in a country that signed the Rome Statute, or if the criminal is from a country that signed it. Simple, right? When the ICC can only take cases if the crime happened after the Rome Statute was created 2002. So, no retroactive stuff. If a country joins late, The ICC only handles crimes that happen after they join. But what about conflicts between countries? Let's say there's a crime, and both Germany and Italy are involved. Who gets to handle the case? Here are the rules that decide. Territorial principle. The country where the crime happened gets first dibs. Makes sense, right? You catch the criminal where the crime went down. Nationality principle. If you're a German and you commit a crime in Italy, Germany might still want to handle it because you're their citizen. Protective principle. If a crime threatens a country's interests, say terrorism, that country gets to handle it, even if the crime happened far away. Universality principle. This is the big one. If a crime is bad enough, like genocide or war crimes, any country, anywhere can step in and prosecute. It's all about protecting humanity. Why should we care about the ICC? The ICC is like the last line of defense when countries don't take care of their own problems. It's there to make sure big criminals, the ones who do the worst things, don't get away with it, even if their country doesn't want to deal with them. It's a bit like the big brother of international law, stepping in when the local laws can't or won't get the job done. How does it work? The UNSC can step in when there's a threat to peace like war crimes, aggression, or major international problems. This is controversial because it lets the UNSC control who gets investigated, even if the country didn't agree to ICC rules. What happens next? The ICC is forced to act, even for countries that aren't part of the treaty. Think of it as universal jurisdiction for the UN, stepping in to prevent major international crimes. 4. The principle of complementarity. What's this? The ICC doesn't take over everything. It's complementary, meaning it only acts when a country isn't doing its job to prosecute crimes, aka state sovereignty still matters. How does it work? If a country is either unable or unwilling to prosecute serious crimes, the ICC steps in. It's about avoiding impunity for criminals. Unwilling. The country just doesn't care or is making things up to protect criminals, like giving someone immunity. Unable. The country is too weak or the justice system is collapsed, no way to catch criminals, gather evidence, or even hold a trial. What happens next? If the country fails to act, the ICC can step in to prosecute those criminals. Why does this matter? The complementarity principle is key because it protects state sovereignty. Countries are incentivized to follow international laws to avoid losing their jurisdiction to the ICC. If they don't take international crimes seriously, they could lose the ability to handle such cases themselves. For example, Germany adapted its laws to handle international crimes, while Italy didn't approve laws for certain serious crimes, like crimes against humanity. If a country doesn't comply, the ICC can jump in and take control. Bottom line. The ICC can start investigating crimes through state requests, on its own, through the UNSC, or when a country fails to prosecute. The complementarity principle keeps everything balanced between international law and state sovereignty, ensuring justice is served when local courts won't or can't act. Hopefully, this breakdown makes the process clearer for you, kind of like the ICC stepping in when no one else will handle the mess. Let me know if you need more details. What is a crime? A crime is like a puzzle made up of different pieces. If one piece is missing, there's no crime, and you can't punish someone for it. Simple, right? In criminal law, this puzzle has two big sections. Actus reus, what you did, the action or omission. Mens rea, what you were thinking, the guilty mind. In civil law systems, they might call these objective element actus reus, subjective element mens rea. Why does the structure of a crime matter? Think of it like building a house. If the foundation, the elements of the crime, is shaky or missing, the whole thing collapses. You can't convict someone unless all the parts of the crime are there. The two main elements of a crime. 1. Actus reus, objective element. This is the action part, what actually happened. It's about the external physical facts. What did the person do? Did they cause harm to someone else? Example. Imagine a driver follows all the traffic rules, but a pedestrian suddenly jumps in front of the car and the pedestrian is hit and killed. Here's the deal. From a purely objective perspective, the driver caused someone's death the actus reus. But since the driver wasn't careless and couldn't foresee the accident, there's no blame. Actus reus isn't enough on its own. That's where mens rea comes in. 2. Mens rea subjective element. This is the mindset, part what the person was thinking or intending at the time. Did they mean to do harm? Were they reckless, negligent, or did they make an honest mistake? Example. A person accidentally grabs the wrong suitcase at the airport. The actus reus, they took someone else's property. But the mens rea, there's none they didn't intend to steal. No mens rea means no crime. Mistakes happen, folks. Other systems three-part model. In some countries like Italy, France, and Germany, they split crimes into 3 parts. Wrongdoing actus reus, the action or harm caused. Absence of justification. Was there a legal reason for the act? E.g., self-defense can make killing lawful. Culpability mens rea. The guilty mind, what the person was thinking or intending. Breaking down actus reus further. Actus reus isn't just the action, it has layers. Conduct, the prohibited behavior, e.g. hitting someone. Harmful consequences, the result of that behavior, e.g. injury or death. Causation, the link between the act and the harm, e.g. did hitting someone cause the injury? Circumstances, the situation around the act. Social harm, the broader impact on society, e.g. theft, undermines trust in property rights. Quick recap. Crime cor actus reus, jouon mens rea. Actus reus, what you did the action. Mens rea, what you were thinking, your intent. If any piece is missing, no crime. Some systems add an extra step. Was the act justified? What's the deal with conduct? Every crime has a conduct. It's the essential element and the prohibited behavior. Think of it like this. Example, killing someone intentionally, e.g. murder. The conduct is the act of killing, but there's also the harmful consequence, which is the death. That's why murder is serious, the harm it causes. 2 types of crimes. Crimes can be split into 2 big categories. Result crimes. These crimes need a specific outcome or result to happen because of the conduct. Example, murder. The result, someone dies. The focus here is on the harmful consequence, and you also have to prove causation that the conduct caused the result. Conduct crimes. Here, the law bans the behavior itself, even if there's no harmful result. Example, driving drunk. Whether or not you cause an accident, doesn't matter, it's still illegal and punishable. Why does this distinction matter? For conduct crimes, the court only needs to prove the prohibited action happened. Once that's done, it's a wrap. For result crimes, the court has to prove the conduct happened. The result harm occurred. The causation that the conduct led to the result. The extras in actus reus. Some crimes need more than just the conduct. Let's look at the extra elements. Possible circumstances. These are external conditions required for the crime to exist. Example, corruption only applies if the person committing the crime is a public official. Sexual assault, rape, requires lack of consent. If the victim consents, no crime. Social harm. This is about the damage or risk to society. Criminal law doesn't punish for the sake of punishing, it punishes when the conduct causes serious harm or an unreasonable risk of harm. Example, crimes like murder, theft, or assault harm things that society values: life, property, safety. Causation in result crimes. For result crimes, causation is key. Judges need to prove The defendant's conduct directly caused the harmful result. No one else or nothing else was responsible for the result. Quick recap. Conduct equals essential in every crime. Result crimes need conduct, yaune, result, yaune, causation. Conduct crimes just need conduct. Sometimes you need circumstances, e.g. public office and corruption, or proof of social harm. What's the deal with conduct in criminal law? First off, conduct is like the foundation of every crime. If there's no conduct, no action, or no failure to act, then there's no crime. Thinking about robbing a bank? Totally legal. Actually robbing the bank? That's when you're in trouble. Action versus omission. Two types of conduct. Action, doing something bad. You do the thing the law says not to do, like stealing a car or punching someone. That's an action easy peasy. Omission, not doing what you're supposed to. You don't do what the law says you should do. Didn't pay your taxes, didn't take care of your kid, boom, that's an omission, and now you're on the hook. Special types of crimes. Status crimes. Sometimes, just being in a certain condition gets you in trouble. Example, being drunk in public. The law's like, how'd you get drunk? Oh, you drank? That's a choice, pal. Possession crimes. Got something illegal in your pocket? Drugs? A stolen item? That's a crime too. They'll ask, did you voluntarily take possession of it? You didn't just accidentally find drugs in your backpack, right? The voluntary part. Here's the thing, your actions have to be voluntary. If you couldn't control what you did, like if you were sleepwalking or someone physically forced you, the law's not going to throw the book at you. Why? Can't scare people into behaving. If you didn't mean to do it, punishment won't stop you from doing it again. Fairness 101. If you didn't act with free will, you don't deserve blame. Simple as that. Voluntary versus intentional. Now, listen closely. Voluntary doesn't mean you meant to do it. Example, you fire your rifle at a deer, but oops, you hit another hunter. Shooting was voluntary, you meant to pull the trigger, but you didn't mean to kill that poor guy, no intention, no mens rea for murder. If it's not voluntary, like your hand just spasms and fires the rifle, then forget about mens rea, you're not even responsible for the action in the first place. Bottom line, conduct equals action or omission. It's got to be voluntary, whether you're doing something bad or failing to do something good. Some crimes, like possession or being drunk in public, look at what you did to end up in that situation. And remember, thinking about a crime, totally legal. Acting on it, better call Saul. When the act's not voluntary, not every action's voluntary. But here's the deal. If your mind can't control what you do, you're usually off the hook. Examples of involuntary acts: instinctive reactions. A bee stings you while driving, and you swerve into someone. It wasn't intentional, it just happened. Mental disorder. If someone's out of touch with reality due to a condition, they might avoid punishment, though they could still end up in a hospital. Intoxication. If you're drunk or high, the law usually says, hey, you got yourself into this mess. Why? You chose to drink or use drugs, so your actions are still seen as voluntary. Omissions. When doing nothing gets you in trouble, most of the time, the law wants you to act freely, so you're punished for doing something wrong, not for not doing something. But sometimes, the law steps in and says, if you don't act, you're in trouble. Why are omissions a big deal? Punishing someone for inaction is a bigger hit on personal freedom. If the law says don't do X, you're free to do anything else. But if the law says you must do Y, then you're not free to do anything else until you handle that. When omissions are punished, crimes of pure omission conduct crimes, these are straightforward. The law says, do this thing, and if you don't, you're guilty. Example, not paying taxes. The law lays it out. Pay up by this date or you're toast. Crimes of commission by omission result crimes. These are trickier. If your failure to act causes harm, you're responsible. Example, letting a child drown when you're their babysitter, you didn't act, and now there's a tragic result. Good Samaritan laws. This is where the law says, hey, if someone's in danger, you've got to help. Sounds noble, right? But it's not asking you to be Superman. Reasonable assistance only. If helping won't endanger you, you should step in or at least call for help. Example, someone collapses on the sidewalk. You don't have to perform CPR if you don't know how, but you should call 911. Where are these laws popular? Countries like Italy, France, and Germany dig these laws. They're all about solidarity. In common law countries like the US or UK, not so much. Why? Freedom is king. They don't want to force people to act. The bystander effect complicates things. If 100 people see someone in danger, who's responsible? Bottom line, if your act isn't voluntary, you're probably not responsible, but if you could have avoided the situation, the law might still come for you. Omissions get punished in limited cases, especially when someone's life or safety depends on you acting. In the end, criminal law is always balancing freedom versus responsibility, and the scales tip differently around the world. So, do your civic duty, but don't expect the law to always hold your hand. Crimes of commission by omission. Here's the deal. Sometimes doing nothing can land you in serious legal trouble. If you have a legal duty to protect someone and you fail to act, you could be held responsible for the harm that happens. Key elements. Legal duty to act. You're not just morally obligated. There has to be a legal duty. This is more than just being a nice guy. Causal link. The harm has to directly result from you not acting. No excuses your failure. Has to be the main reason the harm happened. When do you have a legal duty? 4 main scenarios where the law expects you to step up. Statutory provisions duty by law. Some relationships come with built-in legal obligations. Examples, parents must care for their kids. Doctors must treat patients. Husbands and wives owe each other protection. Voluntary assumption taking responsibility. If you've agreed to care for someone, whether it's through a formal contract or just stepping up, you're responsible. Examples, a nanny has a duty to protect the child. A lifeguard must save swimmers. A guide on a mountain trip is expected to ensure everyone's safety. Creating a risk you mess up, you fix it. If your actions put someone in danger, you've got to help. No running away. Examples, a driver hits a pedestrian. In some places, failing to call for help or ensure the victim's safety could make the driver liable for any extra harm, even death. Contractual duty. This applies when there's a formal or implied agreement. Examples, a private doctor treating a patient under contract or a babysitter caring for a child. Omission versus action. Why it matters. In some cases, jurisdictions only punish the positive act like causing the accident. They might just slap you with a fine for not helping afterward. Other jurisdictions go harder. If you fail to help and the person dies, you can be charged with a more serious crime like murder. Example, the Vanini case, Italy. A man caused harm but didn't help the victim. Instead of splitting it into 2 crimes, the accident and not helping, the court treated his failure to act as a serious offense. Result, he faced severe punishment, not just a minor fine for breaking a Good Samaritan law. Bottom line, the law doesn't always punish people for doing nothing. But when you've got a legal duty, whether from a relationship, a contract, or a situation you created, you better act. Ignoring that duty can turn a bad situation into a criminal charge. And depending on where you are, that could mean a serious penalty. So, if you're responsible for someone, don't ghost them when it matters. Omission and causation. Causation is all about connecting the dots. For someone to be responsible for a harmful result, their failure to act or their action must have directly caused it. No causation, no crime, it's that simple. When does causation matter? Result crimes like murder. There's a gap between what someone did and the harm that followed. The big question, did their action or inaction cause the harm? Example, if someone dies, was it because of the suspect's act or was it something else entirely? conduct crimes like assault. No causation drama heretics clear the act directly caused harm. The but-for test basic rule. This is the starting point. Would the harm have happened if the person didn't act? If yes, they're off the hook. If no, they're in trouble. Problems with the but-for test. Two narrow alternative causes. Example. Charlie lights a house on fire, but a nearby forest fire would have burned it down anyway. By the but-for test, Charlie's off the hook, but that feels wrong, right? Solution. The substantial factor test. Look at the specific result, the house burning at that time and place. If Charlie's fire was a big part of it, he's still responsible. Two broad unrelated or remote causes. Example. A killer's mom gave birth to him. So is she responsible for the murder? Obviously not. Solution. Proximate causation. This limits responsibility to causes that are closely connected to the harm. Think of it like a river. If the current gets weaker or is overtaken by another river, the first cause, Charlie's act, loses its strength. Proximate causation. Keeping it reasonable. Definition. Even if someone's act is a factual cause, it also has to be close enough to the harm not too remote or unforeseeable to count legally. Example. Charlie crashes into Lucas, who ends up in the hospital. Lucas's rival sneaks in and kills him. Is Charlie responsible? Nope, Lucas's death was caused by the rival, not the accident. This rule keeps us from blaming someone for every little thing that happened down the line. Final rule combo of both tests. To hold someone responsible. Their inaction must be the factual cause, but for the conduct, the harm wouldn't have happened. It must also be the proximate cause, not too remote or unforeseeable. There you go, causation, plain and simple. Whether it's action or omission, the law wants to know, did you cause the harm, and was it close enough to blame you for it? That's the game. Criticism of the but-for test. The but-for test, while foundational, encounters practical limitations and requires supplementary doctrines to ensure just outcomes. Let's explore its criticisms and the proposed solutions. 1. Alternative hypothetical causation. The issue. The but-for test may exclude liability in cases where the harmful result would have occurred independently due to another factor. Example. Jake burns his house for insurance money while a nearby forest fire would have burned it anyway. Under the but-for test, Jake may escape liability since the forest fire would have caused the same result. Proposed solution. Substantial factor test. Instead of ruling out causation entirely, consider whether the defendant's action was a substantial factor in producing the specific harmful result. Example application. If Jake's fire burned the house faster or differently than the forest fire would have, his action is a substantial cause of that specific outcome, holding him liable. 2. Excessive scope of liability. The issue. The but-for test can potentially hold individuals liable for remote or unrelated causes that lack a meaningful connection to the harmful result. Example. A killer's mother could theoretically be blamed for a homicide because had she not given birth to the killer, the crime wouldn't have occurred. Proposed solution. Proximate causation. This legal concept limits liability to causes closely related to the harmful event, excluding remote or unforeseeable ones. Proximate or legal causation? Proximate causation helps refine liability by ensuring only relevant and close causes are considered. Direct versus concurring causes. Direct causes. A direct cause exists when no other factors intervene between the conduct and the harmful result. Example. A driver's negligence directly leads to a pedestrian's death. Concurring causes. Other factors intervene between the defendant's conduct and the harmful result. These can be pre-existing conditions, e.g., the victim's illness. Subsequent events, e.g., medical malpractice after an injury. Example. Charlie injures Lucas, who later dies due to a doctor's error during treatment. Standards to evaluate concurring causes. Reasonable foreseeability. Was the intervening event foreseeable from the defendant's perspective? Example. If Charlie knew Lucas might encounter medical complications, his conduct remains a proximate cause. Conversely, unforeseeable complications may sever the causal link. Exceptionality. An intervening cause must be not only unforeseeable, but also exceptional to break the causal link. Example: a meteor strike killing Lucas in the hospital would be exceptional and thus sever causation. Response versus coincidence doctrine. Response. An intervening event is a response if it directly reacts to the defendant's actions, e.g., medical care for injuries caused by the defendant. Coincidence. An intervening event is coincidental if it happens independently of the defendant's actions, e.g., a mob attack in the hospital, unrelated to Charlie's injury. Final takeaway. The but-for test alone cannot account for all nuances in causation. By integrating additional doctrines such as the substantial factor test and proximate causation, the law ensures that liability is assigned only when there is a meaningful, direct, and foreseeable connection between a person's conduct and the harmful result. When do intervening or pre-existing factors interrupt causality? The interruption of causality depends on the nature of the intervening or pre-existing factors and their foreseeability, exceptional nature, or relationship to the defendant's actions. Here is a structured analysis of these factors. 1. Foreseeable factors. Standard. Reasonable foreseeability. A factor is foreseeable if the harmful result could reasonably have been predicted as a consequence of the defendant's conduct. Theory. Adequate causation civil law. The defendant is criminally liable if the harmful result was a reasonably foreseeable outcome of their conduct. Example: Bill scares Julia, who dies of a heart condition. If Bill knew of Julia's condition, he is liable because her death was foreseeable. If Bill had no knowledge of her condition, he is not liable, as the death was unforeseeable. 2. Exceptional or eccentric factors. Standard. Exceptionality. An intervening or pre-existing factor breaks the causal link if it is exceptional or eccentric in nature. Theory. Human causality civil law. Exceptional factors, being highly improbable or unrelated to the defendant's conduct, sever causation. Example: Titus injures Caius in an accident, but Caius later dies in a hospital fire. The fire is an exceptional event that breaks the causal link. Titus is not liable for Caius's death, only for the initial injury. 3. Response and coincidence, common law. Response. An intervening act is considered a response if it is directly connected to and arises from the defendant's conduct. The causal link is not interrupted. Example: Titus shoots Caius, who dies in the hospital due to a doctor's error. The doctor's conduct is a foreseeable response to Titus's actions, so Titus remains liable for Caius's death. Coincidence. An intervening act is a coincidence if it is unrelated to the defendant's actions. The causal link is broken. Example: If Caius dies in a hospital fire after being shot, the fire is coincidental and severs causation. Titus is only liable for the shooting. 4. De minimis contribution. Principle. When the defendant's contribution to the harmful result is negligible, causation may be excluded. Criticism. This method is controversial because distinguishing between minimal and significant contributions can be subjective. 5. Free, deliberate, and informed human intervention. Principle. A defendant may not be liable if an independent human act intervenes, provided the act is free, deliberate, and informed. Example: Caius is injured by Titus and, while recovering, deliberately ends his own life. Caius's independent decision interrupts the causal link, absolving Titus of liability for the death. 6. Role of culpability civil law. Concept. Instead of focusing solely on causation, civil law emphasizes the defendant's mens rea state of mind or culpability in determining liability. If the defendant could not foresee the harmful result or lacked intent, they may not be held criminally liable. Application. In cases with unforeseeable or exceptional factors, the defendant's culpability is examined to assess liability. Example: in the Titus and Caius case, if Titus could not foresee Caius's death in a hospital fire, he lacks culpability and cannot be held liable for the death. Summary: foreseeable factors maintain causality, while exceptional factors sever it. Response maintains causation. Coincidence breaks it. A defendant's culpability is a critical consideration in civil law. Each case requires a nuanced analysis, balancing factual causation with legal causation to ensure just outcomes. What's the deal with HPV? HPV is basically when someone, usually a woman, steps out of line according to some outdated family rules, and the whole family freaks out. We're talking control, shame, and a lot of finger pointing from the peanut gallery, aka the community. 3 main ingredients in this messed up recipe. Control. The family wants to micromanage a woman's life. Shame. When they lose control, some guy feels embarrassed. Community drama. The whole clan gets involved because apparently everyone's honor is on the line. How does it go down? HPV isn't just one type of crime. It's like a combo meal of bad behavior. Forced marriages, honor killings, domestic violence, even pressuring someone to commit honor suicide. The motives? A woman dated someone the family didn't like, had premarital sex, or maybe Gasp chose her own path. That's all it takes to spark the madness. The cultural backstory. Imagine this. In some societies, your actions don't just affect you, they damage the whole family. Honor is like a family heirloom. If you break it, everyone flips out. Men's role. Be tough, be brave, and keep the family's good name. Women's role. Be obedient and modester else. Lose honor, and suddenly everyone's pointing fingers at the family. To fix it, they think punishment is the answer. Spoiler alert, it's not. Why does it happen in Europe? HPV is showing up in immigrant communities. Here's the twist. The parents stick to old school values, but their kids grow up in modern European societies. Conflict? You bet. Families freak out because they feel their culture is slipping away. Forced marriage or violence becomes their twisted way of holding on to group identity. The legal system's response. Europe's been tightening the screws on this stuff. New laws. Forced marriages? Illegal. Female genital mutilation? Double illegal. Protecting victims. They relocate victims, change their names basically, a witness protection program for HPV survivors. Cultural shifts. At first, courts tried to understand the cultural angle. Now, they see it as an aggravating factor. Translation? If you use culture as an excuse for violence, they'll throw the book at you. Why is it still happening? Victims don't report it because they're scared of their own family. Language barriers and lack of integration make it harder to get help. Even when victims step forward, they face more victimization from society. So, what's the takeaway? HPV is a legal and cultural mess. Families think they're protecting their honor, but they're ruining lives. The law's catching up, but until victims feel safe to report it, we've got work to do. You're dealing with honor-based violence and forced marriages and the usual criminal justice system? Yeah, it's got holes big enough to drive a truck through. So what's the alternative? Restorative justice. It's like mediation, but with a heart and maybe a little more oomph. What's the deal with restorative justice? Imagine this. Instead of throwing someone in jail and calling it a day, we sit everyone down safely, of course, and figure out how to fix the mess. It's about healing, not just punishment. Sounds good, right? But there's a twist. It actually works. Safety first. The victim's got to feel protected. No, talk it out nonsense if someone's at risk. Balancing power. No one's getting steamrolled here. This isn't a negotiation between equals. It's a way to level the playing field. Community involvement. Got a trusted elder, a community leader, or someone respected? Bring them in. People listen to their own, trust me. What's happening in the UK and Norway? UK. They're like, official mediation for this stuff? Nah, too risky. But guess what? Community groups stepped up. Sharia councils, tribunals. Let's just say, not always great. Sometimes they push traditions too hard and women lose out. London Kurdish Peace Committee. These folks, they elect community judges who mediate disputes. Informal, but they keep it local and respected. Norway, they're like, let's give RJ a seat at the big table. They've got national mediation services, formal enough to get government backing, chill enough to work, pilot programs, small projects, big results. How does this all shake out? The good stuff. Agreements get made, violence often stops, and people compromise like tweaking dress codes or behavior. Sure, not perfect, but hey, it's progress. Monitoring. Someone's got to keep an eye on things. No slipping back into bad habit. Worst case scenario. If things get dicey, exile happens. Out of sight, out of trouble. Why does it work? Close to home, victims can actually reach these people. No endless red tape. Cultural street cred. The mediators, they get the community vibe. Women matter. Empowerment's the name of the game of victims. Pick what works for them. It's flexible. No cookie-cutter justice here. Every case gets its own game plan. But wait, there's more. Risks. Yeah, it's not perfect. You could still get some pressure to settle for less than ideal. Mediators need top-notch training to avoid screwing it up. Cultural complications. Balancing traditions with fairness? Tricky, but not impossible. Honor-based violence, forced marriages, all that messy business. It's not just some random act of madness. Nah, it's about control, power, and of course, the family's reputation. You want a family to stay honorable? You keep the women in line. Simple, right? But here's the thing. It's not just the one guy, the husband, who's the bad guy. Oh no, my friend, we're talking about the whole family, parents, cousins, uncles. The whole crew stepping in to fix things when the honor's been damaged. It's like a well-oiled machine. And they do this not because they care about the person being hurt, but because they care about looking good in the community. Now, let's get to the fun part, the legal system. Governments don't want to be soft on these crimes. They pass laws, they get all tough, thinking they're solving the problem. But, and here's where it gets juicy, these laws can cause more harm than good. You see, by treating these crimes as cultural issues, you risk stigmatizing entire groups of people. Discrimination, institutional racism, that's what you get when you're not careful. And we know how messy that can get. What do we do, huh? More laws? More jail time? Nah, we need a balance. Enter restorative justice, or RJ, my friends. Here's the kicker. It's not all about locking people up. It's about getting everyone to talk, to understand, and maybe even heal. You got communities handling their own stuff? Great. But when things go off the rails, you bring in the experts. That's when you pull in the big guns like the police. But here's the rub. If you want to make this system work, you have to get communities involved in the conversation. Build a bridge, so to speak. You mix formal law with informal community-based systems. You let people from these communities take charge with some guidance from the big boys upstairs. And bam, you start solving problems. So, what's the bottom line? Stop treating the symptoms and fix the whole system. We need a little cooperation between the authorities and the people who actually live and breathe this stuff. Get the right mix of authority, fairness, and let's face it, a little bit of flexibility. That's how we start solving this problem. You got a problem with that? Call me. I'm Saul Goodman, and I'll get you out of the mess. All right, sit tight. We're talking about causation, and not just any causation. We're talking scientific causation. You know, when the judge asks, but for the defendant's actions, would this terrible event have happened? That's the but for test. Classic stuff, right? But when we start dealing with tricky cases where proving the link isn't so cut and dry, we need to bring in the science, the big guns. But here's where it gets messy. Science doesn't work like law. You can't always get a definite answer. Most of the time, science deals with probabilities, not certainties. And in criminal law, my friends, certainty is the name of the game. We need to be absolutely sure that it was this person's actions that caused that horrible outcome, and that's where things get tough. Let me give you an example. Let's say we've got a guy with HIV. and his wife catches it through sexual intercourse. Now, scientifically, the chance of transmission is low, like 0.01%. So, what do we do with that? Well, Italian law has a neat little trick up its sleeve. As long as there are no other possible explanations, we go ahead and say, yep, it was the husband's fault. Science might not be 100% sure, but if we've eliminated all other possibilities, then we've got enough to convict. That's the no other possible explanation rule. If it couldn't have happened any other way, then boom, causation is established. Now, let's talk about omissive causes, the crimes of omission, where you don't act when you should. You're still responsible, but the big question is, how do we prove that not acting caused harm? That's where it gets tricky. Here, we use a double hypothetical test. First, we ask, what should the defendant have done? Like a doctor who didn't administer the right treatment. What was the duty they neglected? That's step one. Now, for step two, we take the but for test. If the defendant had actually done their duty, would the harm still have occurred? If the answer is yes, then no causation. The omission didn't cause the harm. If it's no, well, then we've got causation. The omission did cause. So there you have it. When the law and science don't exactly get along, we've got ways to make them play nice. You don't need a crystal ball, just a little logic and the right steps to prove causation in tricky cases. We've got two pieces to a crime. First, the actus reus, which is just a fancy term for the wrongful act, the thing that actually happened. And then there's mens rea, the mind behind the crime, or as I like to call it, the guilty mind. You see, it's not just about what you do, but why you do it. Intentions, knowledge, recklessness, negligence. That's what the law's concerned with when it comes to mens rea. Why do we even need this guilty mind thing? Simple. Because if you punish someone for something they didn't mean to do, that's not just wrong, it's unfair. You don't want to punish someone who's blameless. You only go after the people who deserve it, the ones who knew or should have known the consequences of their actions. The whole point of criminal law is to make sure only the blameworthy face the music. So, what happens if someone commits a crime but didn't have any bad intentions? Well, in some cases, we have strict liability. That's when you get punished just for doing the bad act, regardless of whether you meant to or not. Think speeding, you're guilty, no questions asked. That's a controversial one because it kind of goes against the idea that you should only be punished if you were at fault. Now, let's talk about those partial fault crimes. There are situations where you don't have to prove that the person knew something was wrong. For example, let's say someone has sex with a minor. They don't have to know that person's a minor. They just have to engage in the act. Now, that's tricky because it doesn't line up with the whole you need a guilty mind idea. But that's how it works in some places. The crime is about the act, not the person's awareness of the situation. Then there's the result crimes, like murder. You intentionally kill someone, and that's pretty straightforward. But in some cases, you don't need to intend the result. Let's say someone punches someone else, and that punch leads to their death. You didn't intend to kill, but you still caused it. That's called manslaughter, and in some legal systems, you can still be punished for the result, even if you didn't mean for it to happen. The bottom line is, there's this big debate about how much fault is required to convict someone. Some places go all in on strict liability, meaning no fault is needed at all. Others want to make sure there's at least a little bit of negligence involved before someone gets punished. The trick here is balancing fairness with keeping society safe. You don't want to send someone to jail for something they didn't know was going to happen, but you also don't want to let dangerous people off the hook just because they didn't mean to cause harm. Here's the rundown. There are different degrees of blame in the criminal world. It's all about how much intent you've got behind your actions. We've got three main flavors of mens rea. That's the mental state behind the crime. Intention, the big one. You're fully aware of what you're doing and want the outcome. If you intend to commit a crime, you're in deep water. That's the most serious form. You've planned, you've thought about it, and you went for it. The law sees this as a major red flag, and it's no surprise that the penalties are steep. If you intentionally kill someone, bam, murder, life in prison, no questions asked. Recklessness, this is a bit tricky, but in common law systems, it's a step down from intention. It's not that you want the bad outcome, but you don't care enough to avoid it. You know there's a risk, and you go ahead and take it anyway. Think of someone driving at high speed in a busy area. They're not planning to hit anyone, but they sure as heck don't care if they do. This is serious, but not as bad as full intention. Manslaughter could be the charge, and we're talking about a lighter sentence, like 5 years. Negligence, the least severe but still punishable. You weren't aware of the risk, but you should have been. It's like driving and not noticing you're swerving all over the road, but if you paid attention, you could have avoided it. Here, you didn't mean to hurt anyone, but your carelessness led to harm. This one's got a lighter punishment because the person didn't act with bad intention. Now, let's talk about why this matters. It's not just some game of semantics. The degree of intent really changes how much punishment you face. If you're acting intentionally, the system is going to throw the book at you. If you're being reckless or negligent, they'll still punish you, but not as hard. About fairness, right? You don't want to slap someone with a life sentence for a crime they didn't intentionally commit. Then there's this tricky business about the limits of criminal law. Certain crimes require a specific type of mens rea. Some crimes can only be committed with intent, like theft. You can't steal something by accident, right? Same with damaging property, that's intentional. And if you didn't mean to cause harm, you might not be held liable. But let's not forget the psychological angle. Intention is more than just a word in the legal dictionary. It's a two-part thing. You've got the cognitive part, that's the knowing part. You're aware of the consequences, you've thought it through, and then you've got the volitional part, the wanting. Do you want it? Do you desire the outcome? If yes, then you've got intention in full force. In civil law systems, it's all about this idea of dolus directus, direct intent, and dolus intentionalis, intent in general. This split, the cognitive and the volitional, is what gives you that full-blown intent to commit a crime. Bottom line, the law needs to figure out just how guilty you really are, and that's where mens rea comes in. Are you a cold-blooded killer intentional? A careless driver reckless? Or just a bumbling fool negligent? The severity of your crime depends on which box you check, and that affects how much time you're going to spend behind bars. So, that's the scoop. Mens rea is a big deal. It tells us how much blame we can place on someone. Without that, we'd be punishing innocent people just because they happen to be in the wrong place at the wrong time. And trust me, you don't want to be the one on the receiving end of that. 1. Intention dolus. Intention is the most serious fault element in criminal law. It is when an individual knowingly and purposefully acts to achieve a specific result. Think of it as someone choosing to act with a goal in mind. They're not just doing things by accident. This level of mental state is so critical because it shows that the person had a clear purpose behind their actions, which increases their blameworthiness. In legal terms, intention is split into different types across the two main traditions, civil law and common law. In civil law, 3 forms of intention dolus. Dolus intentionalis, general intent. This is the most straightforward kind of intent. A person acts with the purpose of achieving a result. For example, if someone decides to kill another person, they are intentionally trying to cause death. Their goal is clear, to achieve that particular outcome. Dolus directus, direct intent. This is what we typically think of when someone intentionally commits a crime. It's the highest degree of intent because it involves acting with the direct purpose of achieving a result. The person is fully aware of the consequences and actively works to make it happen. Murder, for example, is a crime that requires direct intent. You aim to kill, and that's exactly what you do. Dolus eventualis conditional intention. This one's a bit more complicated. It's when someone doesn't have the direct intention to bring about a result, but they foresee that it's highly likely to happen, and they accept that risk. It's more than just recklessness. It's a conditional acceptance of an outcome that could occur as a result of their actions. For example, if someone sets a fire knowing it could spread and kill people, but they don't care as long as they get what they want, this is dolus eventualis. In common law, two forms of intention, direct intent, dolus directus. Just like in civil law, this is when the person acts with the specific purpose of bringing about a result. This is the most straightforward and serious form of intent. For example, if someone plans to kill another person, their action is intended to cause death. Oblique intent, dolus obliquus. In common law, this is when someone does not intend the exact result, but knows it will almost certainly happen as a consequence of their actions. For example, if a person bombs an airplane to kill one person, but they know with certainty that everyone on the plane will likely die, that's oblique intent. They didn't want to kill everyone, but they foresaw that it would happen, so it's still considered intentional. The key differences: civil law versus common law. Civil law. Civil law systems have a broader approach to intention with three categories: direct intent, dolus directus; general intent, dolus intentionalis; and conditional intent, dolus eventualis. This broader view means that a wider range of cases can be considered intentional, including those where the person did not specifically want the harmful result, but accepted it as a likely outcome. Common law. Common law, in contrast, typically recognizes just two forms of intent: direct intent and oblique intent. While civil law covers more cases under the umbrella of intention, common law might classify those same cases under lesser degrees of culpability. Important distinctions within intention. Motives versus intentions. It's critical to note the difference between the motivation behind an action and the intention of the action. Motivation is why someone might commit a crime, e.g. financial gain. But intention is the result they intend to cause, e.g. death. In law, only the intention to bring about a result matters, not the motive behind it. Proper coincidence between intention and action. For intent to be valid in criminal law, it must coincide properly with the action at the time the crime occurs. If someone intends to kill a person, but accidentally kills them when they're not the intended target, they may not be held responsible if the intention did not exist when the crime occurred. Punishment based on intent. The severity of the punishment is usually tied to the degree of intent. Direct intent. More severe punishment because the person has full control and choice. Oblique intent. Still serious, as the person knows with high certainty the result, even if they didn't specifically want it. Conditional intent. In civil law, this can lead to punishment because the person accepted the risk, but in common law, it might be treated as recklessness or something less severe. The bottom line: intentions matter. They are essential in determining blameworthiness. The more intent someone has in committing a crime, the more severe the punishment. Different legal traditions handle intent differently, but the ultimate aim is to figure out just how blameworthy a person is for their actions and what should happen as a result. Dolus eventualis involves two crucial elements: awareness of the risk. The defendant is fully aware of the potential consequences of their actions, though the harmful result is not the primary objective. The risk might not be certain, but it's significant enough that the perpetrator knows it could occur. Acceptance of the risk. Despite knowing the potential danger, the defendant proceeds with their action, essentially accepting the risk of the negative outcome for the sake of achieving their goal. They may not want the bad outcome, but they are willing to tolerate it. Example 1. Throwing someone into a river. Imagine someone throws another person into a cold river with strong currents. The person doesn't specifically intend to kill the other, but they know that the currents could potentially drown them. The perpetrator decides to act anyway, fully aware of the risk of harm. In this case, the person accepts the risk of death even if it was not their primary intention. Example 2. Mafia. Bombing the judge's house. A mafia member might place a bomb in the house of a judge, intending to kill the judge. However, they are aware that the explosion could also kill the judge's children. Although the death of the children wasn't their goal, the mafia member knowingly takes that risk, accepting it as a side effect of their goal to harm the judge. This is dolus eventualis, because the risk of harm to the children was acknowledged and accepted. Key distinction: conscious negligence versus dolus eventualis. It's important to understand that dolus eventualis differs from conscious negligence. In conscious negligence, the individual is aware of the risk but does not accept it. They may believe that the harmful outcome won't happen, even though they are aware of the risk. For instance, dangerous driving involves the driver acknowledging the risk of an accident, but hoping it won't happen. In this case, the driver does not accept the potential harm. They are not coming to terms with it, but are simply disregarding it. This is not dolus eventualis, because they do not accept the risk. They are merely hopeful that the bad outcome won't materialize. Example, leather belt case. Two individuals plan to steal from a victim. When the victim resists, they decide to strangle him with a leather belt. They know this could kill him, but continue with their actions because they want to subdue him. Although they didn't want to kill the victim, they accepted the possibility of death as a necessary consequence of achieving their goal, getting the money. In this case, dolus eventualis applies because they proceeded with the act while accepting the risk of causing death, even if it was unpleasant to them. In civil law systems, the concept of dolus eventualis is broader in civil law systems than in common law systems. Civil law incorporates a more nuanced view of intention, where the distinction between conscious negligence and dolus eventualis becomes crucial. In these jurisdictions, the law may treat an act as intentional when the defendant was aware of the risk and still chose to proceed, even if the exact outcome wasn't their direct goal. Thus, dolus eventualis essentially holds individuals accountable for acts where they knowingly took a risk, even if the harmful result wasn't their explicit purpose. This highlights a key distinction in how legal systems, particularly civil law versus common law, treat varying levels of intentionality and culpability. Recklessness, huh? All right, let's get down to brass tacks. You're not just any lawyer, you're a lawbreaker. You're not a lawbreaker. You're someone who needs to know what the heck's going on when you're walking that fine line between negligence and intent. Let's talk about recklessness, because it's more fun than it sounds, believe me. Now, recklessness, in the eyes of the law, isn't like your run-of-the-mill, oops, I didn't see that coming kind of mistake. No. Recklessness is when you know something could go wrong, like, really wrong, and you decide to do it anyway. It's like driving a car after a few too many drinks and knowing full well you might end up with a tree as your new best friend, but you do it anyway. Because why? Because you're in a hurry. You like living on the edge. Or maybe you just like the thrill. Now, that's reckless. In common law, we've got two kinds of actors. The ones who have intent, they want the bad result to happen. They aim for it, like hitting someone with a car, because you really want to knock them down. And the ones who are reckless, these reckless folks, they're not intending to hit anyone, but they know they could, and they do it anyway. Think of it like this. You're throwing a party, and the neighbor's window is right next to the tree you're planning on climbing to get that extra beer from the roof, but you decide to climb anyway, knowing the risk that you could crash through the window. That's recklessness. And then there's dolus eventualis. That's a civil law thing, a little different. Basically, it's like recklessness, but they like to call it something fancier. It's when you accept the risk. You don't just know it could happen, you kind of go, hey, I'm okay with it. That's the big difference. If you're doing something to rob a bank and you know someone might get hurt, but you go ahead with it anyway, you're accepting the possibility of harm. Civil law, they might call that intentional, but in common law, it's recklessness. And this whole concept of recklessness evolved. We started with the Caldwell test that was kind of a mess, I won't lie. The court said, hey, if you didn't see the obvious risk, you're reckless. But that was way too broad, like saying you're guilty of speeding just because the speed limit's hard to see. They figured it out with RVG, saying you have to actually be aware of the risk, not just ignore it. This is where the law finally got it right. So, the takeaway? Recklessness is like the Goldilocks of criminal intent. It's not as bad as going in with full intent to harm someone, but it's definitely worse than just being a clueless idiot. It's when you know what might happen and you say, meh, who cares? I'll take my chances. And that, my friend, is the kind of thing that'll land you in hot water, fast. So, yeah, that's recklessness in a nutshell, aware of the risk, but doing it anyway. It's kind of the sweet spot between intent and negligence. Now we're getting into the deep stuff, folks. We've talked about recklessness and we've talked about intent. But you're asking about negligence, and let me tell you, that's where it gets interesting. Negligence is kind of like the underdog of criminal law. Less flashy than reckless or intentional acts, but still enough to land you in prison. Here's the kicker. In civil law, you've got this whole world of conscious negligence. That's where someone knows the risk but hopes like hell it won't happen. Like, hey, I'm driving drunk, but I'll be fine. They still know the danger, but they push their luck anyway. And guess what? In civil law, that's where things get a bit fuzzy because it kind of blends into dolus eventualis, that conscious acceptance of the risk. But in common law, that doesn't fly. Nope. We don't have conscious negligence. It's either recklessness, you know the risk, and go for either negligence, where you don't even notice the risk, but you should have known better. Let's dive deeper into negligence, or what the lawyers like to call culpa. It's the lowest level of blameworthiness. You're not out there plotting anything evil. You're just doing something careless, but it ends up causing harm anyway. It's like when you're speeding on a highway because you're late to your favorite pizza place and boom, you get into an accident. You didn't intend to hurt anyone, and you weren't being reckless, but you weren't careful enough. And that, my friend, is where negligence comes in. You're not aware of the risk, but you should have been. And guess what? The law doesn't care if you're a big shot or a nobody. If you didn't meet the standard of care you're supposed to, you're liable. Now, here's where it gets tricky. The big distinction between recklessness and negligence is about awareness. A reckless person is fully aware of the risk and they say, I'll take my chances. But a negligent person doesn't even know the risk exists, maybe because they're not paying attention. Maybe because they're not as savvy as they should be. But they should have known the risk. They could have avoided it, but they didn't. In common law, we only care about inadvertent negligence. That means you didn't mean to do anything bad, but you weren't careful enough and it hurt someone. No conscious negligence like in civil law. You're not thinking, hey, I might hurt someone, but you're also not being as careful as the law expects. It's like someone not checking their blind spot before changing lanes. They didn't intend to cause harm, but they should have been more careful. The law's like, come on, buddy, you should have known better. Now, in civil law, things get even more complicated with the whole conscious negligence ideates like you know the risk, but you're hoping for the best. You're aware of the risk, but you choose to go ahead anyway. It's still negligence, but it's closer to recklessness. It's all about the actor's state of mind. But in common law, we keep it simple. If you knew the risk, that's recklessness. If you didn't know the risk, that's negligence. And the law punishes it accordingly. So, whether you're dealing with reckless driving, slipping on a banana peel, or just not paying attention when you're texting and walking into a pole, negligence is about what you should have known. And if you miss the boat on that, the law's gonna come knocking. Justifications and excuses. All right, now we're getting into the juicy part, the defenses. This is where things get a little more complex, but don't worry, I've got you covered. You see, every crime has two key parts, the act, the actus reus, and the intent, the mens rea. When both of those things are there, boom, you've got yourself a crime. But sometimes, people need a way out, right? They need a reason why they shouldn't be punished even though they technically committed the act. That's where defenses come in. So what are defenses? Well, they're like a get-out-of-jail-free card, but not just because you say so. These defenses provide reasons that exclude your criminal liability. They don't say the act didn't happen. They say, yeah, it happened, but I had a good reason for doing it. And they fall into two main categories, justifications and excuses. Justifications. Now, when we talk about justifications, we're talking about situations where the law says, hey, what you did was technically a crime, but in this case, it was okay. It's like giving someone permission to break the rules. The most famous justification? Self-defense. If someone's attacking you, the law says you can defend yourself, even if that means using force, sometimes deadly force. The reason? You have a natural right to defend yourself, to preserve your own life. The state can't be there every second, so it lets you take matters into your own hands when you're in immediate danger. It's the same reason you lock your doors at night. You're looking out for yourself. But here's where it gets a bit tricky. If the person attacking you loses their right to life just by attacking you, well, that's what we call the forfeiture approach. It's a little extreme, but it says, if you're attacking someone, your right to live goes out the window. More moderate views say the aggressor's rights are reduced. They lose some of their value because, hey, they started the whole thing. Either way, it's a balancing act between the aggressor's rights and the person defending themselves. Excuses. Now, excuses are a whole different ballgame. This is when the person did the crime, but we say, hey, they didn't deserve to be punished. The act was wrong, but they're not blameworthy for it. Why? Maybe they were insane at the time, or maybe they were under duress, threatened with harm if they didn't do something. The point is, the law says, okay, you broke the law, but we can't blame you because of your mental state or the situation you were in. Take insanity, for example. The person commits a crime, but they were not in their right mind. The law says, we don't expect you to be responsible for actions you took when you couldn't control your behavior. It's a pretty big deal, because it shows the law recognizes the person behind the crime, not just the crime itself. And then you've got situations like the shipwreck story that Kant made famished woe people stranded on an island fighting for survival. One ends up killing the other. The law says, yes, the killing was wrong, but we can't blame the person who did it. The circumstances were too extreme. It wasn't a regular crime, it was a survival situation. So yeah, the law says it's wrong, but it doesn't punish you for it. Conclusion. So, in a nutshell, defenses are there to explain why you might not be liable for something you did. Justifications are about the act saying, this was okay, because I had a good reason. Excuses, on the other hand, are about the person they say, yeah, I did it, but you can't blame me, because I wasn't in my right mind, or I was forced into it. And as always, the key is balance weighing the rights of the person attacked, the person defending themselves, and the context around it. Not every action gets a free pass, but sometimes the law sees things from a different perspective. All right, let's dive into the nitty-gritty of self-defense. This isn't just about throwing punches when someone gets in your face. No, neither are rules. There are boundaries. You see, self-defense is about balancing two key things, your rights and the rights of the aggressor. But here's the catch, those rights aren't equal. You don't just get to go around defending yourself with force anytime someone looks at you wrong. There are limits to self-defense, and knowing them could save you from a whole world of trouble. 1. The attack must be imminent. First rule, you can't just jump the gun. You need to be facing an imminent threat. In other words, the attack needs to be happening right then and there, or at the very least, about to happen. You can't claim self-defense if someone just threatens you, or if the situation hasn't reached a boiling point yet. If the attack hasn't started or is no longer ongoing, it's not self-defense, it's revenge. And revenge? Well, that's a whole different crime, my friend. If the attack has already ended, don't go charging in with your fists or your words that'll only backfire on you. 2. The attack must be wrongful. Second rule, it's gotta be a wrongful attack. If someone's coming after you, but they have a right to be doing so, like, say, an officer is arresting you for something you did wrong, well, you can't defend yourself just because you don't like being caught. Self-defense doesn't apply if you're being lawfully restrained or detained. No free punches for you there. 3. The defense must be necessary. Now, let's talk about the defense. You can only use force if it's necessary. This is where things get tricky. You can't just pick up a baseball bat and start swinging because someone called you a name. The use of force must be the least intrusive way to stop the attack. If there's another way to handle the situation, say, calling the cops or retreating, you better use that. If you can't escape or stop the threat without force, then the law might give you a pass. But remember, it's all about necessity force. Is it your first resort? It's your last one. 4. The defense must be proportionate. And here's where proportionality comes into play. You can't go overboard. The defense has to be proportional to the threat you're facing. If someone's swinging a fist at you, you can't pull out a gun and end their life. But if someone's coming at you with a knife, yeah, you might need more than a slap to the face. The key here is balancing your right to defend yourself and the force that's necessary to stop the attack. Don't escalate it too far. A punch to protect your wallet is fine, but killing someone for a TV, that's a no-go. 5. EU law on proportionality and necessity. And if you're in Europe, there's a bit more clarity. Under Article 2 of the European Convention on Human Rights, ECHR, it says that force should only be used when absolutely necessary. What does that mean? You can only take a life, for example, if there's no other way to defend yourself or others from unlawful violence. The law gives you some leeway, but it doesn't say you can just go around hurting people because they look at you wrong. Force should never be more than necessary because that's the line that makes sure justice is served, not revenge. Saul Goodman's wrap-up. So, there you have it. Self-defense isn't just a free-for-all. You have to meet all these requirements to make sure your actions are legally justified. Imminent threat? Check. Wrongful attack? Check. Necessary force? Proportional force? You better believe it. Just remember, the law won't let you go on a rampage because someone bumped into you at the bar, and the more force you use, the more likely you are to find yourself answering to the law. So use your self-defense rights wisely, or you might just find yourself defending something else like your freedom. In short, self-defense is a balancing act. It's all about making sure the force used is necessary and proportional to the threat, with some hard lines drawn between lawful defense and unlawful retaliation. All right, now that you know the basics of self-defense, let's talk about the issues that can pop up when you're trying to defend yourself. Because trust me, things are never as simple as they seem in the courtroom, especially when it comes to the necessity and proportionality of the force used. 1. Duty to avoid conflicts. Here's the first curveball. You can't claim self-defense if you started the whole thing. If you're the one who initiated the conflict, you can't just claim, hey, I was defending myself when things go south. Now, let's say you start a quarrel with your neighbor and he pulls a gun on you. You're allowed to use self-defense after all. The guy's pointing a weapon at you. But if you're the one who lit the fuse, you're not getting a free pass just because you're scared. 2. Duty to escape or retreat. This one's a biggier treat. If someone's coming at you and you can easily run away or escape the situation, you might have to. But, and it's a big but, if running away would put you in more danger, you don't have to take off. So, if the door's locked and you can't escape without putting yourself in harm's way, that's a green light for self-defense. You don't have to just stand there and take it, especially if there's no safe way out. 3. Home protection from intrusions. Now let's talk about home protection. This is where it gets a little murky. In some jurisdictions, like the UK and Italy, if someone breaks into your house, you're allowed to defend yourself, even with deadly force. Some laws say that home invaders lose their right to life when they enter someone's home unlawfully. So you might be in the clear if you shoot a burglar. But hold on, not all systems agree with that. In some places, like Italy, the law says you can only use deadly force if there's a real threat to your life. So, if someone's running away with your TV, you can't just shoot them in the back. The law says that your life has more value than someone else's stolen goods. 4. Public defense, crime prevention. Next, we get into public defense. What about the police? Can they use force to stop a crime or arrest someone? The short answer is yes. Police officers often have the right to use force to prevent crimes or catch criminals. But the same rules apply. The force must be proportional to the threat they face. A cop can't just start shooting everyone who runs from the law. But, And this is important. In some places, like under EU law, the police are held to a higher standard when using force, especially when it involves the use of life-threatening force. 5. Self-defense excess. Okay, let's say you're defending yourself, but you go a little too far. Maybe you were fearful or angry, and you end up using more force than necessary. Well, in some jurisdictions, that's still excused. We call this self-defense excess. The key here is that the act is still wrong, but you might be excused for the emotional state you were in. Now, there are two types of excess to think about. Intensive excess. This happens when you go overboard with the amount of force you use. Like, you could have just shot someone in the leg to stop them, but you shot them in the chest and they died. That's intensive excess, and while it's still wrong, some systems might forgive it if your state of mind was affected by fear or rage. Extensive excess. Then there's the extensive excess. This is when you keep going even after the threat is over. Say you're in a fight, you've already got the upper hand, but you keep pounding on your opponent until they're dead. The attack has ended, but you just kept going. That's a gray area, and the law doesn't always look too kindly on it. Some jurisdictions might still excuse this if the person was emotionally overcome by fear or anger during the event. 6. Different legal systems and excuses. All right, it's time to talk about how different legal systems handle this. In Germany, for instance, the defendant might be excused if the excessive force was a direct result of the emotional state they were in, like fear or rage, but not because they were drunk or out of control. In places like Italy, though, it's a little more complicated. The law looks at whether the excess was intentional or not. If you intended to go too far, you're in big trouble murder. If it was just negligent, you might be looking at a charge of manslaughter. Either way, excessive force doesn't get a free pass, even if it's excused. Saul Goodman's wrap-up. So, there's a lot to consider when it comes to self-defense. The bottom line is, you need to think before you act. If you go overboard, the law might not back you up. Self-defense isn't a blank check to do whatever you want. You have to balance the threat with the force you use. If you don't, you could find yourself on the wrong side of the law, even if you were just trying to stay alive. So, before you defend yourself, make sure you've got the right to do so and that you're doing it within the limits. Trust me, it's worth it to know where those lines are. All right, let's switch gears and talk about some defenses that could come in handy when you're facing criminal charges. We're not just talking about self-defense anymore. There are a few more tricks up your sleeve. Let me break it down for you. 1. Mistake of belief putative self-defense. First up, we've got a defense called mistake of belief. Now, imagine this. You're walking down the street at night and you think someone's coming at you, about to attack. In a panic, you defend yourself, but oops, you were mistaken. There was no threat at all. But because you thought you were in danger, the law might excuse you. That's the essence of this defense. You made a mistake, but the belief that you were in danger was reasonable at the time. Take a situation where a boy running late at night thinks someone's coming up behind him to harm him. He reacts by defending himself, but it turns out the person wasn't attacking at all. They were just walking by. Even though he was mistaken, as long as his belief was reasonable, he could be excused. But, and this is important, if he should have noticed the lack of threat, and his mistake was due to negligence, like not paying attention, he could be charged with something less severe, like manslaughter. 2. Defense of necessity. Now, let's talk about defense of necessity. This one's a bit tricky. Picture this. You're faced with an imminent danger, and in order to prevent a greater harm, you commit a crime. That's the essence of necessity. It's not exactly the same as self-defense, because here, you're not protecting yourself from an aggressor, you're creating harm to protect someone or something else. For example, let's say you're stuck in a burning building, and the only way out is to break a window. You're committing a crime, property damage, but the act is justified because you're protecting yourself from the greater danger of the fire. In the law, we're talking about choosing the lesser of two evils. You're choosing to sacrifice something valuable like property to save yourself from a far worse harm like death. End quote. 3. Justified necessity versus duress. Now, there's a distinction between justified necessity and duress. I know, it sounds complicated, but stick with me. Justified necessity is when the defendant commits a crime because there's a clear objective need to protect a more important interest, like in the fire example, where breaking the window is justified because it saves you from a deadly situation. Then there's duress, which is when you're forced to commit a crime because someone else is coercing you, either through a direct threat or psychological pressure. There are two flavors of duress. Duress by threat. This is when someone forces you to commit a crime by threatening you with harm. For example, let's say someone blackmails you or threatens to hurt your family unless you do something illegal. It's still wrong, but the law might excuse you because you were under psychological pressure. Duress by circumstance. This one's a little broader. It's when you commit a crime to avoid some terrible consequence, but it's not due to a direct threat from another person. For example, if you're fleeing a burning building and you break into someone's house to escape, it's duress by circumstance. There was no one threatening you, but the situation left you with no other choice. 4. Distinction between necessity and duress. Now, I know what you're thinking. Is duress just another form of necessity? They're similar, but not the same. Necessity is about making a rational decision to pick the lesser evil, while duress is about being pushed into a decision by external forces, whether it's someone threatening you or the circumstances forcing you to act. So, necessity is based on a choice you make, while duress is about not having any real freedom to make a choice. Here's where it gets even more interesting. Some legal systems, like common law, distinguish between the two, treating them differently. Necessity could be a full justification for the crime, whereas duress could be seen as an excuse you still did something wrong, but you were under too much pressure to be blamed. In places like Italy, they just lump them together and treat them as one, making it harder to tell if they're justifying your actions or just excusing them. Saul Goodman's wrap-up. So, you've got a couple of defenses to work with if you find yourself in a sticky situation. Whether it's mistake of belief or necessity, or whether you're under duress, each defense has its nuances. The key takeaway? Sometimes the law understands that you're put in tough spots, but it's all about how reasonable your actions were given the circumstances. But don't get too cocky, because reasonable can mean different things in different places. If you've got a defense, use it wisely and make sure your lawyer knows how to spin it for the best result. All right, listen up. Now we're diving into some real controversial territory. Homicide and whether you can ever excuse the taking of a life. Buckle up, because the questions we're about to tackle are no joke. Can you ever justify killing an innocent person to save another? Let's break this down from a legal perspective, and I'll tell you why it gets complicated. 1. Can homicide ever be excused? So here's the big question. Can a person ever be excused for taking a life? The law says that killing another human is one of the most serious acts you can commit, and most legal systems don't like the idea of excusing a homicide. In fact, many argue that life is invaluable, and that you cannot put a price on Itone. Life should not be sacrificed to save another, as all lives hold equal value. But hold on, this isn't a cut and dried issue. Some jurisdictions take a compromise approach. In countries like Germany, they allow duress as an excuse for homicide in certain extreme situations, believing that self-preservation is an instinct so strong that even the law can't hold someone accountable for acting out of fear for their life. 2. The dilemma of homicide in extreme cases. Let's make this real for a second. What happens if you have two conjoined twins, sharing a heart, and one of them will die if separated, but both will die if not? This exact dilemma was presented in the UK courts, where the life of one twin could be saved, but only at the cost of the other twin's life. The court allowed the separation, arguing that the necessity defense could apply in this extreme case to save one life instead of letting both die. The sacrifice of one life was justified as the lesser evil. This case showed that under certain circumstances, even prohibitions against evaluating lives could be set aside. Sometimes life preservation may allow for difficult choices, even in cases of homicide. 3. The strict requirements of necessity and duress. Now, let's talk about the strict requirements that apply when invoking necessity or duress, because these aren't just get-out-of-jail-free cards. You need a clear justification, and these defenses are usually only accepted in extreme circumstances. Here are the main requirements. A. Imminent danger. The first rule is that there has to be imminent danger threatening an important legal interest, like someone's life, bodily integrity, or personal liberty. For instance, you can't use duress to justify hurting someone over a property dispute that doesn't fly. You've got to be facing imminent danger, and the situation has to demand immediate action. Just like self-defense, the defendant must be forced to act and unable to avoid the danger in any other. B. Proportionality. The next thing you need to keep in mind is proportionality. The act of defense must fit the threat. If the danger is minor, like a little shove, you can't go killing someone to prevent minor injuries or some reparable harm is not justified. The law wants to make sure the response is not excessive. You're supposed to choose the lesser. So if you're a doctor facing an emergency situation and the patient can't consent to a procedure, you might need to act based on necessity, but again, you can't just go around doing things willy-nilly. There has to be a balance. The life-saving action must be in proportion to the harm you're preventing. 4. Application of necessity in medical field. Take a look at the medical field. If a doctor has a patient who can't consent, for instance, they're unconscious, the doctor can still perform a life-saving procedure under the defense of necessity. It's a judgment call, but just because it's necessary doesn't mean the doctor can go wild and perform any kind of procedure. The doctor still has to weigh the harm, the danger, and the urgency of the situation. 5. Duress and necessity in different jurisdictions. The way the law treats duress and necessity varies too. In the UK, the defense of necessity can't excuse homicide. They don't allow the justification of killing someone, even in extreme situations, to save another life. On the other hand, in Germany, duress can be a valid excuse for homicide in extreme cases. And in Italy, it's kind of in the middle. Duress is accepted as an excuse, but only under very specific and extreme circumstances. Saul Goodman's wrap-up. So there you have it. Homicide is a tough nut to crack when it comes to excuses. Imminent danger and proportionality are the core principles, but the context and jurisdiction you're in will make all the difference. In extreme cases, where self-preservation is the only choice, the law might allow some wiggle room, but don't bet on getting away with it unless you're facing a real-life dilemma, because as the law sees it, lives are precious and not something to trade lightly. All right, folks, this one's a tough pill to swallow, but let's break it down. Insanity as a defense. Now, this isn't about being crazy, but about whether a person is mentally capable of understanding their actions at the time they committed a crime. Think of it as the ultimate excuse in "La Wife, you're insane." You might not be held criminally responsible. But here's where things get tricky. 1. Insanity as an excuse. In criminal law, insanity is seen as an excuse rather than a justification. Basically, if someone has a mental disorder and at the time of committing a crime, they were unable to understand their actions or control their behavior, they cannot be held criminally liable. This is because they didn't have the capacity to form criminal intent, and that's a key element of any crime. Now, the rationale behind this is twofold. First, we want to protect people who can't control their actions due to mental illness. If a person can't control their conduct, then the usual purposes of criminal law punishment, deterrence, needn't really apply. If someone doesn't have the capacity to act rationally, it's simply unfair to punish them for something they didn't fully understand. 2. The legal framework and guarantees. The law guarantees that people who lack this capacity, who don't have full insight into their actions, can't be held accountable in the traditional sense. In legal terms, this is called the principle of culpability. It's about being morally autonomous and rational. If you don't meet that bar, you can't be culpable. And criminal liability, that's all based on the assumption that you can think, reason, and act like a normal person. If you can't, the system says no punishment. but there are still consequences. 3. Public safety and treatment. Bhutan, here's the kicker: insanity doesn't mean you walk away scotangent free. Most legal systems say that while you can't be punished, you can still be detained and treated. So, instead of a prison sentence, an insane defendant might be sent to a mental hospital where they can get treatment. In some places, this treatment can go on for a very long time, indefinitely. In fact, as long as the person is still considered dangerous. Now, this part of the law gets controversial. We're talking about taking away someone's freedom, but not as a punishment, more as a preventive measure. You might not be locked in a cell, but you could be locked away in a mental institution, under supervision and forced treatment for years, sometimes forever, until the system decides you're no longer a threat. 4. Controversy around security measures. The real trouble starts when people get stuck in these hospitals for long periods of time, sometimes longer than a regular prison sentence. People have even argued that being in a mental hospital could be worse than prison in some cases. Sure, you're not technically being punished, but you're not exactly free either. You're in a limbo of sorts, neither free nor punished. However, in recent years, especially in places like Italy, there have been some changes. Now, it's not just automatic to send someone to a mental hospital when they're found insane. A judge has to make that decision, and they only apply it if the person's dangerous to themselves or others. Additionally, there's a limit to how long someone can be kept under supervision. This is a big step forward because it prevents indefinite detention, which was a big issue before. 5. The ongoing debate. Even with these reforms, the whole concept of insanity as a defense is still highly controversial. People argue about whether it's fair to take away someone's freedom without charging them with a crime. In some cases, being committed to a mental hospital could be worse than serving a prison sentence. Saul Goodman's wrap-up. So, in the end, insanity is not a free pass. You don't get off scotangent free just because you have a mental disorder. Sure, you might not face traditional punishment, but you could still be locked away for a long time, under strict supervision, depending on whether or not you're considered a danger. And, let me tell you, that's a sensitive field. It's one thing to be a prisoner, but it's a whole different ball game when you're in a mental hospital without knowing when you'll be set free. In summary, insanity is a legal excuse, not a justification, where a person with a mental disorder cannot be held criminally responsible. However, this does not mean they are free. They may be detained in a mental hospital and subjected to long-term treatment or supervision, potentially indefinitely. While this system ensures protection for those with mental illnesses, it raises significant controversies, particularly regarding the fairness of depriving a person's freedom without a traditional criminal sentence. Insanity defense. Requirements and considerations. The insanity defense is an excuse used to exclude criminal responsibility due to a mental disorder. Here are the core requirements for applying this defense, with variations based on legal systems. 1. Mental disorder requirement. To apply the insanity defense, it must be established that the defendant suffered from a relevant mental disorder at the time of committing the offense. This disorder must be significant enough to qualify as a disease of the mind. This term typically refers to pathological disorders, e.g., schizophrenia, cerebral trauma, but in some systems, it has been expanded to include personality disorders and conditions that may not be strictly pathological, but still impair mental functioning. Narrow view. Excludes disorders like emotional responses, e.g. jealousy causing a murder. Broad view. Includes various mental health issues, even those that are not traditionally considered diseases in the medical sense. 2. Defect of reason. For the insanity defense to be applicable, the mental disorder must cause a defect of reason, meaning the person must be unable to understand the nature of their actions or restrain themselves from committing the offense. This defect must be directly linked to the commission of the offense. Causal link. The mental disorder must have played a role in causing the criminal conduct. Simply having a mental illness isn't sufficient for the defense unless it's directly related to the crime. 3. Diminished capacity, partial insanity. In some cases, the mental disorder does not completely impair the individual's capacity to understand or act with restraint. This condition is known as diminished capacity or partial insanity. It means the person still had some mental control, but their decision-making abilities were significantly impaired. In these cases, the person may still be guilty, but the punishment may be diminished, such as in murder cases where the sentence could be reduced. 4. Intoxication and insanity. What happens if the defendant claims that drug or alcohol intoxication led to the commission of the crime? The issue is controversial. Intoxication can indeed impair a person's ability to understand and act consciously. However, intoxication is generally not accepted as a defense for criminal behavior because the person has voluntarily created the condition. Exception. In rare cases where severe intoxication leads to a condition that resembles a permanent mental illness, it may be considered for the insanity defense. Minimum age of criminal responsibility. The minimum age of criminal responsibility varies significantly across different legal systems. But the concept is based on the idea that younger individuals may not yet have the mental maturity to understand the consequences of their actions. Below are some examples from different jurisdictions. Age limits across jurisdictions. Italy, 14 years old. France, 13 years old. Scotland, 8 years old. United States, generally 10 years old in most states. In some countries, no minimum age exists, but there may still be a presumption of non-responsibility for those under a certain age. General approach. Under the minimum age, the individual is automatically excluded from criminal responsibility and cannot be prosecuted for a crime. Above the minimum age, the legal system evaluates whether the individual had the mental capacity to understand the nature and consequences of their actions. This is typically done on a case-by-case basis, focusing on the individual's cognitive abilities. Special considerations for minors. In places like Italy, even when a minor is found criminally responsible, they are not treated the same as adults. For example, life imprisonment is prohibited for minors. Alternative punishments such as probation are favored. Juvenile facilities are separate from adult prisons to ensure age-appropriate treatment. Imprisonment for minors occurs only in exceptional cases. Summary. The insanity defense requires a mental disorder at the time of the offense, resulting in a defect of reason that links the disorder to the criminal act. Partial insanity may reduce punishment but does not completely excuse the offense. Intoxication generally does not qualify as a defense unless it leads to a permanent mental condition. Minimum age of criminal responsibility varies by jurisdiction, with countries setting a lower threshold, e.g. 14 years in Italy. Minors under this age are automatically excluded from criminal responsibility, and special measures are often applied instead of traditional penalties. Well, my esteemed students, that brings us to the end of this lecture on criminal law. We've traversed the complex landscapes of defenses, whether it be the nuanced terrain of insanity or the delicate balance of necessity and duress. Remember, these defenses are not mere theoretical concepts, but rather the core principles that define justice and fairness in the law. With that, our examination of criminal law concludes for now. Until next time, reflect on these principles and how they might apply in the real world. Class dismissed.